emergency hearing we scheduled late last night. I appreciate y'all being here on the short notice. This is Teague versus House Legislative Rules Committee et al. 2026 CP 403393. We were able to get defense counsel copied and present here as well. Yes, ma'am. This is y'all's motion.
Thank you, Your Honor. May it please the court.
Yes, ma'am.
Kathleen McDaniel and Lydia Hendricks for the plaintiffs. Your Honor, before I get started, we have filed a memorandum, a supplemental memorandum, and we have a set of exhibits. If I could hand these up to the court.
Yes, please.
And I've also given a copy to opposing counsel.
Very well. Thank you.
Your Honor, you may, I'm sure you're aware that this is the 250th anniversary of the signing of the Declaration of Independence. Last May 1st, our law firm, along with several other local organizations, sponsored a law day at the federal court with the theme, the rule of law and the American dream. In addition to just having a lovely ceremony with Judge Anderson, reciting our oath of attorney's oath, we also sponsored a CLE on the rule of law and why it is important in our contemporary society. It's hard to explain to ourselves sometimes and to the public what is the rule of law. But the World Justice Project has defined it as having essentially 4 main pillars. And those pillars are all going to be important in our conversation today.
And let me just, procedurally wise,
Yes.
We're on short notice. Judge McGee has civil court at 9:30 here.
Mm-hmm.
I actually am sitting on the Supreme Court, so I have oral arguments a little bit later this morning. So I'm going to give you as much time between now and 9:30 as possible.
Yes.
I'll give you all a chance to respond. When I don't get to any supplemental briefings will be allowed, but I just want to give you that.
Thank
I
you.
didn't mean to cut you off.
I appreciate that. Thank you. I could go all day about the rule of law. I'm rather passionate about it. But as the World Justice Project defines it, there's 4 main pillars. The first is accountability, and that means that everyone, the citizenry, the government, all branches of government, are accountable under the same laws. There's second pillar is that the laws are just, and that means that we have clear, publicized, and stable laws that everyone understands what they are and knows what is expected of them. The third is open government. And open government is what we're here today to talk about, the Freedom of Information Act, the ability to have transparency and to participate in government activities. And the fourth pillar of the rule of law is accessible justice. And that is where an independent judiciary comes into play to be able to hold the other 2 branches of government accountable for their actions. So we have to have an independent judiciary, stable laws that people know what they are and can anticipate. We need to have accountability for everyone under the law, and then finally open and transparent government. Those are how the World Justice Project measures the rule of law across the world. There has, over the last 10 years, been a significant decline in the quantifiable amount of the rule of law in almost every country in the world. For example, the rule of law, their index goes from 1 to 0 on lots of different factors. The United States is about 40 out of 143 countries in terms of our democracy and the rule of law. So we're not at the top, we're kind of in the middle there. But that number, the amount of openness, transparency, stability in our law, that has been trending down. And it has been trending down because of things happening just like what happened in the dead of night, Monday night. We are here because a rule changed that had a significant impact on what is going to ultimately be how we are represented in Congress. It seems like a small thing when you just think about, oh, well, you just changed one little rule. But the implications of that ripple far greater than we can possibly anticipate at this point. When I say that the rule of law is important and how does this violate the rule of law, We mentioned open and transparent. FOIA is the Freedom of Information Act in our state that requires every public body to have open meetings and to provide 24-hour notice of those open meetings. What the House Rules Committee did Monday night is that they had a meeting, called a meeting at 7:07 p.m., had the meeting set for 7:15 p.m., and at that meeting, they completely changed how the debate would be handled for the redistricting bill that's moving through the General Assembly at lightning speed right now. And what they did is, instead of allowing the House members to put in as many amendments as they feel were necessary to represent their constituents, they limited, I believe for the first time ever, the number of amendments that each member could put in to one amendment per person, per member, and they limited them on the amount of time that they could even speak about that amendment. In addition, in the House order, the resolution that went before the Rules Committee is Resolution 5709. And that resolution, we have a copy of it in the packet that I handed up to you. Let me find that. But what it says is that not only did it limit the amendments in the debate at the time while the bill was pending in front of the House, it also anticipated that once the bill went to the Senate, there would be amendments, and then it would come back to the House for consideration of the Senate's amendments. And it even said a greater restriction on debate at that point, whereas the majority and the minority would each get to put one amendment on the table and have 1 hour each for debate, if and when that bill comes back from the Senate. That's important because at 12:39 last night, the House voted to approve the redistricting bill. Again, in the dead of night, not a whole lot of people are up. My clients were up there watching things happen. So now it will go to the Senate. Our concern is that the opposing counsel will say, well, the deed is done. What remedy could there possibly be at this point? But there's a lot of remedies that there could be at this point, Your Honor. What we want this court to find is that the failure of the House to give 24-hour notice for the Rules Committee meeting was a violation of the Freedom of Information Act. We haven't seen any briefing because this is such a quick turnaround on this hearing, but we anticipate that the defendants will argue that House Rule 4.4 provides the ability for the Speaker of the House to waive that 24-hour requirement. In the email that Mr. Parenti sent to you yesterday afternoon, he quoted Rule 4.4 for the proposition that the Speaker can waive that 24-hour notice provision at his discretion. What he left out of that email to you was the introductory clause that says only in exigent circumstances can the Speaker of the House exercise his discretion to waive the 24-hour notice. We have pored over the transcript, the journals, everything from May 18th on Monday. There's no mention anywhere of any exigent circumstances. There's no emergency. There was nothing in the record that would give the Speaker of the House the ability to say that there was any sort of would then have the discretion to waive that 24-hour notice. So, Your Honor, we believe that that was a violation of the Freedom of Information Act. It's interesting that there could be an argument that the Freedom of Information Act does not apply to the House's representatives. But that's exactly what Speaker Smith said on the record when at 7:07 they noticed the meeting for the House Rules Committee. 7:15 they convened the meeting. By 8:15 they were back on the floor of the House calling for a vote and by 8:33 p.m., less than an hour and a half after the meeting had even been noticed, the House had voted to approve that rule amendment. Obviously, some of the House members were concerned about the open meetings requirement, and Representative King asked for a point of order, said, did you have to give 24 hours notice? And at that point, Speaker Smith, and I want to get the quote for you. Let's see, where is that, Lydia? He said, FOIA doesn't apply to us. This is the internal affairs of the House, and we don't have to comply with the Freedom of Information Act, which is a shocking violation of the open government pillar of the rule of law. It is even more shocking when you consider that the Freedom of Information Act specifically discusses that the legislature and all of the committees thereof are public bodies as defined by the Freedom of Information Act. So the Freedom of Information Act definitely does apply to them. They cannot create rules. Their self-made rules cannot contradict, certainly can't contradict the Constitution, and they also cannot contradict state law. To the extent that the House or the Senate would be able to create their own rules to bypass the 24-hour meeting notice, there's nothing that would stop them from creating a rule to simply do away with all of the provisions of the Freedom of Information Act. So they have to be bound by that. The separation of powers argument, there is a limit to what each branch of government can do to infringe on another branch. Finding that the vote violate the failure to have the 24-hour meeting notice violated the Freedom of Information Act, then invalidated any of the votes that came after that, that is not an infringement on the separation of powers. We are not here saying that we're actually not arguing at this point that the limitation on debate was unconstitutional or violates some statute. All we're talking about is the process used to get to that deliberation. So we are not infringing on how the House does what they need to do. We are asking the House to comply with the law that everybody else in the country, in the state, has to comply with. There are lots of cases out there where the remedy for a public body's violation of the open meeting laws is to, in fact, void the action that they took in a meeting that did not comply with the notice requirement. And that is what we're asking the court to do today. We are asking you to determine first, to make a declaratory judgment, a declaratory judgment act, that the House and its committees and its members and its speaker are subject to the Freedom of Information Act, just like everybody else in the state. And their rules actually don't contradict that. The exigent circumstances in their Rule 4.4 is analogous to the emergency circumstances in the Freedom of Information Act. We're asking you to determine that they have violated the Freedom of Information Act and to determine that all of the actions taken after that are null and void, and to reset the clock back to the status quo ante so that the rules prior to May 18th are the rules that apply to the House, at the very least, prospectively going forward, to issue an injunction directing the House to reset the rules back to what they were prior to the vote on May 18th. So, Your Honor, we certainly think that there is a remedy to this. The damage, a lot of damage has been done by them moving forward so quickly to have this vote. However, that can be undone by you. You have the ability to require the legislature to abide by the rule of law, to abide by FOIA, to abide by the accountability, open laws, and the stability of law so that everyone benefits from fair and just laws. Your Honor, I'm happy to answer any questions you might have.
At what point, when it comes to separation of powers, we talk about infringement, and we talk about 4.1, am I supposed to question the Speaker of the House of a separate branch of government about what he considers exigent, if they can do that or not? Am I to tell him what to do, what I think is exigent, but I think rules he can bypass under their own rules, which are, there's no problem with those rules, but the application of them, at what point am I stepping into the General Assembly and crossing that threshold? That's a concern.
That is, in this situation where I think we have a really easy answer to that. There is no exigent situation. If there had been some statement on the record that if Speaker Smith had said, we've got an emergency here, we have to, he could identify some facial emergency, then we would have to consider, is that a valid, objectively reasonable exigent circumstance? But there's nothing in the record that indicates that anybody did this because there was an emergency. They didn't, there's no indication that the waiver of the 24-hour notice was related in any way to an exigent circumstance. Now, it may have been in their hearts and their minds, but it's not in the record, and there's no testimony, there's no affidavit, there's nothing before you today that gives any indication that there was any exigent circumstance whatsoever. So for this case, you don't have to reach that question.
Okay, thank you. Yes, sir.
Good morning, Your Honor. May it please the court. Michael Prento, Maynard Nexon on behalf of the defendants. Your Honor, I'm very cognizant of the court's time this morning, and we'll try to be brief. But this is a very simple issue of the separation of powers, as Your Honor recognized. What plaintiffs are asking the court to do today is to second-guess the judgment of the legislature in setting its own procedural rules under the Constitution, which it is allowed to do under Article 3, Section 12. And the Supreme Court of this state has made it clear that the legislature is free to set its own rules and govern its own procedures as long as those are within the Constitution. There are no constitutional claims here today. This is brought under state statute. And so the longstanding rules of the Supreme Court show that those statutes, the state statutes that plaintiffs seek relief under, do not govern the House rules here. Specifically, Rule 4.4 does say that it is in the sole discretion of the Speaker to waive any notice requirements. And that's exactly what happened here. There is no requirement in the law or in the rules that require the Speaker to put on the record what those exigent circumstances might be. Clearly, this is a process that is moving fast. We're in a special session. The exigent circumstances were clear by the process that was going on. But there's no record, there's no requirement that the Speaker or anyone at the House has to put those reasons on the public record in a transcript or by affidavit to prove that it is an exigent circumstance. The rule states that it is in the Speaker's sole discretion to waive that requirement.
What were the exigent circumstances?
Yes, Your Honor. So
Your Honor, I would object because there's nothing in the record on that point, but.
Well,
yeah.
for the record, I'm gonna let him answer that, and obviously your objection will be noted for the record, but just for my consideration, since it was an emergency last night, he might have to supplement. I don't know if I have time to supplement, but I'm just curious as to what that might be, but noted for the record.
And Your Honor, happy to answer that. I don't, as a threshold issue, I don't think we reached that as to what the actual circumstances are because of the separation of powers doctrine, but it is clear because the legislature is in a special session that there are the redistricting bills and other bills are moving quickly through the system. There were debates for hours. I think it was about 10 hours where 9 amendments were gone through, and there was voluminous testimony on karate and volleyball and other things that were obstructive to the process. And that created the exigency that the Rules Committee needed to act to pass this rule. And Your Honor, if I may pass up, I have a copy of the rule, and I also have a copy of a court order from 2019 from Judge Hood, if I may pass it up, that I think squarely addresses this issue. And I'll pass a copy to opposing counsel also. And Your Honor, just for, to direct the court, there is a tab in Judge Hood's order. But this issue has been squarely addressed by this court before, and in the supplemental brief we received about 20 minutes before this hearing, plaintiffs agree that the issue is whether the South Carolina House of Representatives can circumvent the FOIA the Freedom of Information Act. I don't agree with the characterization of circumvent there, but what Judge Hood said in his order was that a legislative rule, and it was dealing with a different rule at the time, it was dealing with legislative caucuses. Judge Hood found that the passage of a legislative rule did exempt that body from the FOIA requirements. We think that that case is directly on point and governs the exact issue that plaintiffs present to the court here. Again, I'm cognizant of the court's time, so I'm happy if you have any other questions. But the main point here is that the House has the ability under the Constitution to govern its own procedures. They follow their rules, use their rules, and that is not something now that the court can second guess the judgment of the General Assembly on their internal procedures.
All right, thank you.
Thank you, Your Honor.
I just scanning through this order quickly. I haven't read it all, but it appears one of the points is that there's a dispute as to whether a legislative caucus is a public body. We're not talking about definitions under the Freedom of Information Act here. Everyone knows what an open meeting is. Everyone knows that the legislature is a public body. And we're not talking about the rule itself. We're talking about the process that was used to get the rule enacted. And I want to make sure that it's clear that the speaker's discretion is only as to whether or not to waive the 24 hours notice. It's not within his discretion to simply decide that something is an exigent circumstance, because if that were the case, why would there ever be 24 hours notice given if the speaker could simply determine that everything was exigent? That's got to be an objective standard that's used. So it's not up to the speaker to solely determine that something in his sole discretion is exigent. I think that the argument about how quickly things have been moving with redistricting is, and to the extent that that created an exigency, that the House has created its own exigency, and they cannot use that self-manufactured speed of trying to ram this legislation through to claim that there's now some exigent circumstance that necessitates waiver of 24-hour notice period.
But the governor called back the legislature, correct?
The governor did, yes.
I mean, this is a special legislative session.
That is correct. But the governor did what they had to do. It simply, he called them back into session. So it is up to them to determine what they wanted to discuss, what they're going to debate, the bills that they were going to take up. So the House has manufactured this speed themselves. As to exigent circumstances, the notice of the meeting, the notice and agenda, all it says is discussion of rules resolution. It doesn't give any indication that there would be a vote. If there were going to be something about it being exigent, such that you didn't have to have 24 hours notice, that agenda would have been the place to have put that. And there's nothing on there that says what's actually going to happen to the vote, or that it is an emergency that vote needs to be taken. And the last point that I want to make is that, we do have an affidavit for attorney's fees. The Freedom of Information Act allows the recovery of attorney's fees if the citizen who brings the case is a prevailing party. And so I have not put that into the public record, but if I've given a copy of it to opposing counsel, and Your Honor, if I may hand that up, we would certainly ask for attorney's fees in the amount of $8,857.06.
Now, with attorney's fees, unless there's a good faith basis, correct?
No, Your Honor. That is a different statute. That's under Article 15.
Okay.
That one. Yeah, this one is prevailing party gets attorney's fees. And obviously everything is always up to the discretion of the court, but this one is a little bit different than Your Honor, that is it if you have any other questions.
Right on time. Well, I appreciate y'all's condensed arguments and being here on short notice. What I'm gonna do is I'm gonna take this under advisement at this point. For the memos and complaints, motions, everything you have, if you will email me a PDF copy, if you can do that within the next hour,
Yes.
when you get back to your office. If you haven't already e-filed it for the public index, that takes a longer process, so just go ahead and email it to me so I can have a copy of that. It's my understanding is that this has moved on to the Senate and they are starting process on this later this afternoon.
That is correct.
Obviously, this is an emergency, and every time y'all are in here, y'all need a quick ruling. And so, what I'm going to do is I'm going to take this under advisement, review everything you send me, and I'll get a decision to you by later this morning, as best I can. On a side note, I know trying to find a judge, late night, short courtrooms and all that, I understand that can be frustrating. So, as the chief administrative judge, if there is any other actions filed in this case related to this congressional redistricting in Richland County, I'll just go ahead and take jurisdiction of that and assign it to myself if necessary. That way, if a hearing needs to happen quickly, I obviously have the courtrooms and I can make that happen sooner rather than later. And that's for both sides here or any sides.
Certainly.
And Judge,
Yes.
if I may, if we could just ask maybe until 11 o'clock this morning to submit a written brief to Your Honor with our position responding to the supplemental motion that we received 20 minutes before the hearing, we would appreciate that opportunity to respond in writing.
We'll give you till 11 a.m. and then that'll still give you the rest of the morning to make a ruling.
Thank you, Your Honor.
Okay, so email me all that stuff. Anything else from Plaintiff's counsel before we adjourn?
Nothing, Your Honor.
Anything from defense counsel?
Nothing further, Your Honor. Thank you.
Mr. Prente, Ms. McDaniel, Ms. Hendricks, thank y'all very much.
Thank you.
I'll start shortly. Thank y'all for being here. If any media needed something signed, Mr. Monk, if you need it,